You're watching The Legal Breakdown. Glenn, you and I have spoken quite a bit about the U.S. Attorney in Washington, D.C. That's Ed Martin. He's just pulled a move that really crosses the Rubicon in terms of weaponizing this government against its political opponents. Can you explain what just happened?
So, Brian, in what might be the single most breathtaking abuse of power, abuse of office, and prosecutorial misconduct that I've ever come across in my 30 years as a prosecutor, the top prosecutor in D.C., a guy named Ed Martin, the acting U.S. attorney, wrote a letter to Georgetown University School of Law saying, "It's come to my attention that you are teaching and promoting DEI at Georgetown, threatening to investigate them for it." Some breaking news, it's not a crime, so you can't investigate them for it, and pledging that no student from Georgetown Law will be considered for any employment, no internship, fellowship, or attorney position at the D.C. U.S. Attorney's Office if you keep teaching and promoting DEI, diversity, equity, and inclusivity. This is sort of beyond prosecutorial misconduct. Cutting right to the chase, Brian, this is like the top prosecutor in D.C. threatening to criminally investigate and prosecute someone who has absolutely committed no crime, no evidence to even support initiating an investigation. This should lead to the downfall and disbarment of Ed Martin. Of course, we'll see, where this story goes from here.
Well, Glenn, we spoke in our last episode about how Ed Martin has been referred to the D.C. Bar Council for an ethical investigation. Could this right here be another example that's used against him in this upcoming referral?
Yeah, the last referral, which came just days ago from 8 of the Democrats on the Senate Judiciary Committee, a letter highlighted several unethical acts that Ed Martin has taken since he has been the interim U.S. attorney for a matter of about a month or more now. And yet this one, believe it or not, ups the unethical ante. And just so our viewers understand, Brian, that I'm not overstating what Ed Martin threatened to do to Georgetown University School of Law. This comes directly from the letter Ed Martin authored. He said, "It's come to my attention reliably that Georgetown Law School continues to teach and promote DEI. This is unacceptable." Let me just pause there. Are you effing kidding me? Who are you to tell an institution of higher learning what is acceptable or unacceptable? Sport, look, you're in the business of investigating and prosecuting crimes, not dictating to universities what is or is not acceptable to teach, in your opinion. That was my addition. Ed Martin's letter to Georgetown continues. "I have begun an inquiry into this. In other words, I'm investigating you." The only investigative power a prosecutor has, a U.S. attorney has, is the power of a criminal investigation. It's not like he can, open what would be tantamount to some kind of a congressional inquiry because I just want to learn more about this. That's why it's such an egregious abuse of power, position, and office. It's hard for me to wrap my mind around. So he says, "I have begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? Second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it?" And then he goes on to say, by the way, any Georgetown Law student will be banned from ever working at the D.C. U.S. Attorney's Office. This, it almost sounds like a Saturday Night Live skit, but it is real, it is unethical, and it is prosecutorial misconduct.
So, Glenn, my question was going to be, is what he's doing legal? Clearly it's not. Clearly you can't use the powers of the U.S. Attorney's Office to pressure a private institution into changing their curriculum to better comport with the political ideology of this administration. That notwithstanding, hasn't the marker been laid down now where, okay, even if this thing goes to court and a judge says you can't do this, well, he still laid down the marker and said, so long as DEI continues to exist at Georgetown University, so long as it continues to be employed at Georgetown University, we're not going to hire people. And so even if a judge says what you did was wrong, isn't it true that he's already made it abundantly clear what he wants, and that so long as DEI continues to exist, that they just won't hire people out of the DOJ, even if his threats unto themselves aren't legal or proper?
Yeah, so this is probably my favorite question, and this will be my favorite part of our discussion. Because Ed Martin could be sued personally, in my opinion, and here's why I say that. First of all, there is something called qualified immunity. So the courts cooked up this doctrine that says, and I would argue rightfully so, if you're a federal government employee or officer and you're acting within the scope of your official duties, you can't be sued for it. That makes sense, because imagine if I was an IRS worker and I was looking at your tax returns, Brian, I said, you know what? I disagree with this deduction you took. I don't think you should be allowed to take it in accordance with IRS laws and regulations. And then what? You could sue me, drag me into court, make me pay money to defend myself against what was official governmental conduct. The answer is no. Why? Because I have qualified immunity. Here is the beauty of just how dramatic Ed Martin's abuse of office, power, and position is. This is not within his official governmental duties as a prosecutor. What does that mean? No qualified immunity for you, and you can be sued personally, and you can be made to pay out damages. That would be money for what you have just done, which the dean of Georgetown Law, in a response letter, said is plainly unconstitutional. We have a First Amendment right to teach whatever we damn well please. He didn't say damn in the letter, that was my addition. But he made clear that this is unconstitutional conduct that is so far beyond the official scope of Ed Martin's duties that I believe a successful lawsuit can be brought, should be brought, and I hope the many lawyers who are either at Georgetown University on the faculty or who are a product of an excellent law school education, having graduated from Georgetown University School of Law, are already hard at work putting that civil suit together, because that will hit Ed Martin where it hurts, in his pocketbook, and I think it will end up perhaps even putting an end to this abusive claim of Ed Martin that we won't even employ anybody coming out of Georgetown. So, he better buckle up, because he may have a whole lot of personal liability coming his way.
Glenn, how do we even know, though, if these candidates who've applied for jobs at the DOJ, if they don't get hired, how do we know that it's because he won't hire them because Georgetown still has its DEI policies in place? He might very well just say, no, you weren't qualified, that's why we didn't hire you. And these folks, the candidates who were not brought on, they're going to say, well, we weren't hired because Ed Martin doesn't like our alma mater, and so we're being discriminated against because our alma mater, their political ideology doesn't comport with his. And so how do you prove that the reason that these folks don't get hired in the future is truly because they are the product of this institution and not the fact that they were just unqualified?
Yeah, I mean, it's a great question, and sort of the devil's in the details. There are two related concepts. One is standing and one is damages. Standing means, kind of as you're suggesting, well, who gets to sue? Because we don't know if these people were not hired or not considered to be hired because of what Ed Martin said, or maybe just because of the needs of the U.S. Attorney's Office or the academic record of this particular person who was seeking employment there. That's called standing. So who has the right to sue? Because who has been harmed? The concept of harm also is intertwined with the concept of damages, just a fancy word for whether you have suffered some sort of financial damage as a result of what Ed Martin has just done. Unconstitutionally tell a law school it can't teach what it wants to teach, and if it does, none of its students will be considered for employment. So these are tricky, and these are things that moving forward, lawyers would have to litigate. Lawyers would have to, I don't want to get down into the weeds of civil litigation, but propound interrogatories, fancy word for questions, depose people like Ed Martin and others about hiring practices. But for example, if 25 students who graduated from Georgetown University who had really strong academic records were not even granted interviews, and 25 students from George Washington University School of Law with comparable or even lesser academic accomplishments were granted interviews. What are we doing? We're building a record that Ed Martin is deploying his retaliatory, unconstitutional scheme against Georgetown University students. But I really think the better course here is not to wait on damages, not to wait until this thing plays itself out even further. It's really to bring a lawsuit against Ed Martin personally for doing what? Violating the Constitution by running roughshod over Georgetown Law's First Amendment rights to teach what it chooses to teach, and then see if they can recover damages personally from him. Now, damages, again, punitive damages. There are compensatory damages and punitive damages. Compensatory damages is, look, I wanted to work there. I was wrongfully denied the opportunity to work there. I therefore lost X number of dollars. And there are people who project that out, accountants, in this kind of litigation. But punitive damages are a whole different thing. Punitive damages are designed to punish the wrongdoer. In this case, it is a high government official who has so clearly abused his position, his authority, and his prosecutorial discretion and responsibilities. And if he is held liable for punitive damages to be punished for that, well, then, frankly, the sky's the limit.
Wouldn't it also be a pretty easy case and I completely understand and agree with that. Going back to what I was saying before, wouldn't it be a pretty easy way to tell? I mean, he's laid his marker down in the sand that they won't be hiring anybody from Georgetown. And so all they would have to do is look at how many graduates they've hired from Georgetown in the past. And even if it's 5 or 10 or 15 or 20, if you have 0 now, then that's the whole case proved out right there. And if he does hire a few, well, then that's really him giving up on his plan anyway. And so if he sticks by his word and says, I'm laying my marker down in the sand and we're definitely not going to hire anybody from Georgetown because it continues to implement DEI policies, well, then if you have 0, then you've really proved your own thesis out. You've shown that you were doing the exact thing that you're being accused of, and that's a pretty easy case for prosecutors to prove against you.
Yeah, but let's play that out. That will take time. That will take the next graduating class from Georgetown Law.
Right.
They will then have to take the bar. They will then have to apply for jobs. All of this can take a very long time. And all the while, think about this, Brian. This letter that says this investigation is hanging over your head, Georgetown, will do some real atmospheric damage at a minimum to Georgetown and the people who teach there and the students who are deciding whether to go there or not. The time is now to fight this lawlessness and unconstitutionality and abuse of power and position by guys like Ed Martin. Get into court. Maybe the first thing you do is seek a preliminary injunction saying you have to put a stop, Judge, to this, unconstitutional scheme to try to punish Georgetown University law students, although there's been no transgression, criminal or otherwise, by the faculty of the law school. The time is now to get into court and fight this stuff.
I couldn't agree more, and luckily enough, it seems that there is probably no shortage of lawyers who are willing to represent Georgetown Law. So, look, I will definitely stay on top of this with you, Glenn, and as it continues to play itself out for those who are watching right now, if you want to follow along, please make sure to subscribe. I'll put the links to both of our channels right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.